Okay, this is a 200 jury charge. Ready, begin. One who aids and abets is not guilty of the particular crime that, to one's knowledge, his confederates are contemplating committing, but one is also liable for the natural and reasonable or probable consequences of any act that one knowingly aided and or encouraged. A person does aid and abet the commission of a crime if, with knowledge of the unlawful purpose of the perpetration of the crime, one aids, promotes, encourages, or instigates by act or advice the commission of such crime. In this case, mere presence at the scene of the crime, which does not by itself assist the commission of the crimes, does not amount to aiding and abetting. Mere knowledge that a crime is being committed and the failure to prevent it does not amount to aiding and abetting. In the crime charged in count 3 of the information, namely the charge of arson, there must exist a union or joint operation of acts or conduct and general criminal intent. To constitute general criminal intent, it is not necessary that there should exist an intent to violate the law. When a person intentionally does that which the law declares to be a crime, he is acting with general criminal intent, even though he may not know that his act or conduct is unlawful. The specific intent required is included in the definition of the crimes charged. The intent with which an act is done is shown in the following way: by a statement of intent made by a defendant, by circumstances attending the act, the manner in which it is completed, the means and methods used, and the soundness of mind and discretion of the person committing the act. For the purposes of the case on trial here today, you must assume that the defendant was of sound mind at the time of the alleged conduct, which, as it is charged, constituted the crime described in the information. Ladies and gentlemen of the jury, do you have questions before you retire to the jury room for your deliberations? Members of the jury, we come to the point in the instructions where we must define the word homicide and the word murder. Homicide means the killing of a human being by another, either lawfully or unlawfully. As used in these instructions, the word homicide includes murder and manslaughter, which are unlawful, and the acts of excusable and justifiable homicides, which are lawful. The defendant is charged in count 1 of the information with the commission of the crime or murder, a violation of Section 284 of the Wisconsin State Penal Code. The crime of murder is defined as the unlawful killing of a human being with malice aforethought. In order to prove the commission of the crime of murder, each of the following elements must be proved: 1, that a human being was indeed killed; 2, that the killing was unlawful; and 3, that the killing was done with the presence of malice aforethought. Malice is either express or implied. Malice is implied when the killing is a direct causal result of the perpetration or the attempt to perpetrate a felony inherently dangerous to human life. When it is shown that a killing resulted from the intentional doing of an act with express or implied malice, no other mental state needs to be shown to establish the mental state of malice aforethought. The mental state constituting malice aforethought does not necessarily require any ill will or hatred of the person who is killed. A forethought does not imply deliberation or the lapse of considerable time. It only means that the required mental state must precede rather than follow the act. The unlawful killing of a human being, whether intentional, unintentional, or accidental, which occurs as a result of the commission of or attempt to commit the crime of robbery, and where there was in the mind of the perpetrator the specific intent to commit such crime, is murder of the first degree. The specific intent to commit robbery and the commission or attempt to commit such crime must be proved beyond a reasonable doubt. If a human being is killed by any one of several people engaged in the perpetration of or attempt to perpetrate the crime of robbery, all persons who either directly and actively commit the act constituting such crime, or who, with knowledge of the unlawful purpose of the perpetration of the crime, aid, abet, promote, encourage, or instigate by act or advice its commission, are guilty of murder of the first degree, whether the killing is intentional, unintentional, or accidental. The defendant is charged in count 2 of the information with commission of the crime of robbery, a violation of section 214 of the Wisconsin State Penal Code. The crime of robbery is the taking of personal property in the possession of another from his person or immediate presence and against his will, accomplished by means of force or fear. In order to prove the commission of the crime of robbery, each of the following elements must be proved. 1, that a person had possession of property of some value, however slight that value might be. 2, that such property was taken from such person or from his immediate presence or possession. 3, that such property was taken against the will of such person. 4, that the taking was accomplished through force or violence or by fear of intimidation or by both. And 5, that such property was taken with the specific intent to permanently deprive the owner, such person of the immediate or permanent possession of such property. Members of the jury, in addition, the defendant is charged in count 3 of the information with the commission of the crime of grand theft, a violation of section 888 of the Wisconsin State Penal Code. Every person who steals, takes, or drives away the vehicle of another with the specific intent to deprive such person permanently of the property is guilty of the crime of grand theft of a vehicle. In order to prove the commission of such a crime, each of the following elements must be proved. 1, that a person took or drove away the vehicle that belonged to another person, and 2, that when such person took or drove away such vehicle, 1 had the specific intent to deprive the owner permanently of such property. Members of the jury, that completes my instructions to you. At this time, we will take a brief recess. Counsel and members of the jury, please return to the courtroom in 15 minutes for further directions from the court. Ladies and gentlemen of the jury, this is People of the State of Kansas versus Long. You have been instructed as to all of the rules of law that may be necessary for you to come to a verdict. Whether some of the instructions will apply in your deliberations will depend upon your determination of the facts that you have heard in this courtroom. You will disregard any instruction which applies to a state of facts which you determine does not exist. You must not conclude from the facts that any instruction that the court has given that the court is therein expressing any opinion as to the facts. You are reminded that both the people and the defendant are entitled to the individual opinion of each juror. It is the duty of each of you, ladies and gentlemen of the jury, to consider the evidence for the purpose of arriving at a verdict if you are able to do so. Each of you must decide the case for yourself, but you should do so only after a discussion of the evidence and all of the instructions with the other members of the jury. You should not hesitate to change an opinion if you are convinced it is in error. However, you should not be influenced to decide any question in a particular way because a majority of the members of the jury or any of the members of the jury favor one decision as opposed to another. The attitude and the conduct of the members of the jury at the beginning of their deliberations are matters of considerable importance in this trial. It is rarely productive or in any way good for a member of the jury at the outset to make some type of expression of opinion on the case or to state how one intends to vote. When one does that at the beginning, the sense of pride may be aroused and one may hesitate to change position, even if it is shown that the position that was taken is incorrect. Remember that you are not partisans or advocates in this matter, you are judges. In your deliberations, the subject of penalty or punishment is not to be discussed or considered in any way. That is a matter which must not in any way affect the final verdict. The written instructions now being given to you will be made available in the jury room during your deliberations. They must not be defaced in any way. Do not write upon them. You will find that the instructions may be either printed, typewritten, or handwritten. Some of the printed or typewritten instructions may be modified by typewritten entries or handwritten entries. Blanks in the printed instructions may be filled in by typing or handwriting. Also, portions of printed or typewritten instructions may have been deleted by lining out. You are not to be concerned with the reasons for any modifications that have been made. Also, you must disregard any deleted part of an instruction and not speculate either what it was or what is the reason for its deletion. Members of the jury, every part of an instruction, whether it is printed, typed, or handwritten, is of equal importance in the trial of this case. You are to be governed only by the instruction in its very final form or wording, whether printed, typed, or handwritten. In this case, there are two possible verdicts as to each of the counts. These various possible verdicts are set forth in the forms of verdict which you will receive. Only one of the possible verdicts may be returned by you as to any particular count. If you all have agreed upon one verdict as to a particular count, the corresponding form is the only verdict form to be signed as to that count. The other forms are to be left blank or unsigned. You shall now retire and select one of your number to act as foreman of the jury. The foreman will preside over your deliberations. In order to reach a verdict, all 12 jurors must agree to the final decision. As soon as all of you have agreed upon a verdict, you shall have it dated and signed by the foreman. Then, members of the jury, you will return to the courtroom with your verdict. Ms. Clerk, please swear the bailiff. Ladies and gentlemen of the jury and alternate members of the jury, you have been sworn and selected to be a juror in this case. I shall now instruct you as to your basic functions, duties, and conduct. At the conclusion of this case, I will give to you further instructions on the law. Please be reminded that all of the court's instructions given to you, whether given before, during, or after the giving of the testimony, are of equal importance. Your decision should be based on the facts and the law. You must determine the facts from the evidence that is received during the trial. Do not look to any other source for evidence. What is a fact? A fact is something that is proved by the evidence or by a stipulation. What is a stipulation? A stipulation is an agreement between the attorneys regarding the facts. You must apply the law that I state to you to the facts in this case as you determine them to be, and in this way you will arrive at your verdict. You must accept and follow the law as I stated to you. This is regardless of whether you agree with it or not. If anything concerning the law is said by the attorneys in their arguments or any other time during the course of this trial that conflicts with the instructions I have given to you, you must follow the instructions only. You must not be influenced by pity for the defendant or by prejudice against him. You must not be biased against the defendant because he has been arrested for this offense, charged with the crime, and brought to trial. None of those circumstances is evidence of guilt, and you must not infer or assume from any or all of them that he is more likely to be guilty than not guilty. You must not be influenced by mere sentiment, conjecture, sympathy, passion, prejudice, or public opinion or feeling. Both the people and the defendant have a right to expect that you will conscientiously consider and weigh all of the evidence, apply the law to it, and reach a just verdict regardless of the consequences. Statements that are made by the attorneys during the trial are not evidence. However, if the attorney or attorneys stipulate or agree to a fact, you must regard that fact as proven. If an objection is sustained to a question, do not guess what the answer might have been. Do not speculate as to the reason that the objection was given. Ladies and gentlemen of the jury, do not assume to be true any insinuation suggested by a question asked of a witness. A question is not evidence and may be considered only as helps you to understand the answer. Do not consider for any purpose any offer of evidence that is rejected or any evidence that is stricken by the court. Treat the evidence as though you never heard it. You must not independently investigate the facts or the law or consider or discuss the facts as to which there is no evidence. You must not, on your own, visit the scene of the crime, conduct experiments outside of court, consult books and reference sources such as dictionaries, the internet, or consult any persons for additional information. Ladies and gentlemen of the jury, you must not converse among yourselves or with anyone else on any subject connected with this trial, except when all of the following conditions exist. 1. The case has been submitted to you for your decision by the court, following the arguments by counsel and the jury instructions. 2. You are discussing the case with a fellow juror. 3. All 12 jurors are present in the jury deliberation room. I will remind you that you will be given notebooks and pencils to take notes. Please leave them on your seats when you leave each day and at each recess. You will be able to take them into the jury room when you deliberate. The bailiff will pick up your notebooks each day after the conclusion of the proceedings for that day. Do not permit anyone to look at your notes. They should be strictly confidential. While note-taking, do not let that task distract you from the proceeding at hand. Remember, you are the judges of the believability of each of the witnesses. Notes should be only an aid to memory. They should not take precedence over your own recollection. A member of the jury who does not take notes should rely on his or her own recollection of the evidence and not be influenced by the fact that the other juror took notes. Notes are for the person's own personal use to refresh memory and recollection of the evidence. During the trial, you have a right and you may request that the court reporter read back relevant testimony. Should a readback be requested, ladies and gentlemen of the jury, the court reporter will be permitted to read only that portion that the court instructs her to read. Before the readback, I will first consult with the lawyers. You are not permitted to deliberate during the court reporter's presence. You cannot ask the court reporter questions. Additional readback must be requested of all the court if you are interested in hearing other portions of the trial transcript. In addition, you are not to deliberate during the court reporter's presence. As for you, the alternate jurors, you are bound by all of these admonitions. You must not converse among yourselves or with anyone else on any topic connected with this trial. You must not form or express any opinion until the case is submitted to you. This means that until such time as you are substituted in for one of the 12 jurors, only then should you begin deliberations in this case.